A very good morning to all the students. Hope you all have seen part 1 and part 2 of chapter 9 of social science. In the part 2 we discussed about right to freedom, right against exploitation, and moving ahead in part 3 we will discuss right to freedom of religion. See, any citizen of India can follow any religion of choice. See, any citizen can follow any religion according to their choice, and they can promote and propagate the same in a mentioned in the provisions of a Constitution of India. Also, it is been mentioned. But this right is to be enjoyed within permissible limits so that it does not affect the freedom of public administration. See, it should be enjoyed in a permitted limits only, and it should not affect the freedom of public administration. Morality and health of society. The religious gathering, offering or prayers are not included in this. The state of India does not have any religion of its own, or the Indian state. See, the state does not have any religion of its own, it is to be said, or the Indian state is not run by any principles of any religion or sector. The state cannot interfere. They cannot interfere in the religious matter or religious belief of any group. See, they are free to follow any religion, and the state cannot interfere in the religion. And the religions group have been given the freedom. The religious group, they are given the freedom to establish any religion organization and can manage and administer them for religious and philanthropic aims. See, they have the rights to follow, and any religious organization, they can manage and administrate their religion's aim. And the state cannot use the fund which is they are getting through this. The state are not able to use them through the public taxes or public fund for the benefit and the development of any specific religion or sect. The educational institution, they are running on the government grant, cannot impart religious education. See, the education institution which are running on government grant, they cannot impart any religious education, or they cannot compel the student to participate in any religion education, or they can attend any religion meeting. The next is cultural and educational rights. People of various religion, various language and cultures live in India. See, India is a cultural state. So in India, the various different religion, various language, culture, all the people live in India. The people of India has a right to preserve their language, script, cultural identity and ethnicity. Means a state that belong to a social group and they has a common national or cultural tradition. So they have to preserve all these things: language, script, cultural identity, ethnicity, or any educational institution which rely on the government grant cannot deny admission on the grounds of religion. See, if there is any educational institution that depends on with full trust on the government grant, they cannot deny the admission on the basis of religion, caste, creed, language, or any other reason. If an individual that appeals to vote on the ground of religion, caste, or language, then it is considered as a malpractice, as according to the act as per in the act 123 bracket 3. Any of the state can frame a law and provide the rights to a citizen. See, any of them can frame, they can frame the law and they can provide the right to its citizen also, and to form it and to manage of the educational institute that are based on the cultural and linguistic minorities. The state shall not discriminate in giving educational grant or educational scholarship. See, the state, they cannot discriminate by giving them the educational grant or educational scholarship. Why? In the form that educational fund to the any linguistic or religious minority institution. And if the state desire to take over or confiscate the property of minority institution, then it can do only after giving proper returns. See, if the state or the institutions, if the state, they are desiring to give to give over the property of minority institution, so they can do it, but only after giving proper returns to them. And in this way, important provisions in context of educational institution has been made in our constitution. The next is right to constitutional remedies. See, the no matter how many laws are being framed or how many provisions that are made in the fundamental rights, if these are not implemented if these all are not implemented well, then there remains no meaning of such freedom or rights. See, all these constitutional remedies which are being made fundamental rights, if they are not implemented in the proper way, then there is no meaning of such freedom or right. And therefore a provision has to be made in the constitution for the implements of this right, and under it right to right in the Supreme Court and can make the violations of the fundamental right. See, this right has been accepted to the right of constitutional remedies, and the Supreme Court plays an important role in protection. See, this in this the Supreme Court is at the top, and they play a very important role in what, in protecting our fundamental rights. And for this, if the court find it necessary, if they find it necessary, then they can give order, instruction, or decrees. They can do anything. And the apex court, the court, that is the apex court, is vested with the powers. They are been given the powers given by the constitution, which is given by constitution, that nobody can oppose it. And if any person who puts a complaint against any state, if the person has problem and they keep the complaint against any state for the violation of any fundamental right, then the Supreme Court can exercise its right. Then the Supreme Court listens and they exercise that its rights. Dr. Babasaheb Ambedkar has considered this right as soul of the constitution. See, according to the Babasaheb Ambedkar, he has considered this right to be what, as a soul of the constitution. And the parliament can hand over the power. The parliament has a right to hand over the power to such order of any court. And if the state legislative assembly, if they frame any laws, if they are framing any law and which is violent the fundamental rights or not in the congruence, if they are violates or in the fundamental right or they are not congruence, then the Supreme Court can stop. They has a right to stop the state for this. And thus these right provided any opportunity to any of the citizen to approach court for the violation of fundamental rights. The constitution provides the fundamental right. This constitution, they also provide the fundamental right to all the citizens, Indian citizens. And this right they are giving against the government, that is center and states. And the fundamental rights are applicable. This is applicable to all the citizens and all the time, but can be suspended. They can be suspended when, during the time of emergency, when there is an emergency time. And no state can form any law. See, in this it is said that no state can form any law which takes away the fundamental right of the citizens. No state cannot form any law which can be taken, all these fundamental right that can be taken from this citizen. Hope you all have understood till here. In the next part we will read ahead.